The Alabama Supreme Court has upheld a law that would allow the governor to take steps against civil disorder, according to al.com. Welcome to the Political Watchman. Alabama Governor Kay Ivey signed a bill in April authorizing state authorities to use all necessary means when responding to riots or other civil disorder, including using deadly force if necessary, and the court ruled this week that it was not unconstitutional. A federal judge in Alabama has decided that the law about protests is legal. This law is older, so people were worried that it was racist. But the judge said that it was okay because this law protects protests. What is the Civil Disorder Law? The Civil Disorder Law, Alabama Code Section 13A11-7.1, is a law prohibiting certain kinds of willful and unlawful violence associated with the intentional disruption of lawful assembly and was enacted to replace the now obsolete 1838 Riot Act, which had fallen into disuse after being used as a legal tool to end labor protests in the 19th century. In the late 19th century, a labor movement of coal miners developed in many regions of the United States. Labor was held to be an essential part of human freedom and economic progress, but laws in many states prohibited most forms of union activity. Unions were often prosecuted on charges such as conspiracy and criminal syndicalism. In Alabama, the state's radical Ku Klux Klan group targeted black miners, beating union activists, destroying homes and killing members of their families. Alabama's governor at the time, Thomas Kilby Sims, was a staunch supporter of union activism. He was a lifelong Confederate veteran who had fought against the United States during the Civil War. He was allied with the Democratic Party in state politics. Sims used his police power to crack down on union activity and take control of coal strikes in Birmingham areas such as Maxwell Street and Tarrant. Although the coal fields encompassed the whole state of Alabama, the majority of mining was concentrated in these districts. Sims obtained a federal injunction against those charged with violating his laws, which essentially denied them their First Amendment rights to freedom of assembly. The Civil Disorder Law was not created by the Alabama legislature or governor as some have claimed. It is a federal criminal statute that forbids violence during a riot and does not apply to labor disputes. The U.S. Supreme Court affirmed the Civil Disorder Law's constitutionality in the 1992 case of United States v. Hagerty. Judge Hub Harrington, who was removed from office by voters for his decisions that went against conservative principles, such as not allowing the Ten Commandments to be hung in classrooms or similar rulings, had denied a petition to have the Civil Disorder Law declared unconstitutional. The act makes it a crime for anyone participating in a riot to burn or damage any building, street, bridge or other structure and carries a maximum prison sentence of 20 years. U.S. District Court Judge Terry Moorer's decision Thursday afternoon in favor of prosecutors clears the way for Tia Pugh, 22, to face trial next week on a single felony charge: that she violated the Civil Disorder Law by smashing a police car window with a bat during a protest in Mobile 6 days after a black man, George Floyd, died in the custody of Minneapolis police. Two lawyers for Pugh challenged the law on many different legal things. They said that it is called the Civil Obedience Act, and we think that they were trying to make fun of Martin Luther King Jr. and other people who used civil disobedience during the 1960s, when there was a lot of racism in America. The government wanted to take the case away. They called it a coordinated effort from lawyers to find a way for people accused of violence during last year's racial justice protests to escape punishment. However, Judge Moorer said that the law is constitutional. He also said that the law has not been used in a long time and now it's being used in dozens of cases related to the storming of the Capitol. Civil disorder laws are not used often. They were used during the George Floyd protests and more recently against people who protested on January 6, 2021 in Washington, D.C. The people in the protest are different. They are of different races and genders and they have different opinions. Moorer wrote a long opinion that rejected the defense's argument. They said that the law does not follow federalism principles in the Constitution because it does not require a connection between civil disorder and interstate commerce. Still, Pugh will be able to raise a different argument at her trial. She might say that there is not enough evidence that the protest she took part in actually disrupted commerce. The prosecutor said police closed an off-ramp from the interstate during the demonstration and told trucks with hazardous cargoes to detour. "We do not know." Pugh's lead attorney, Gordon Armstrong, called the ruling disappointing, but not entirely unexpected, adding that a ruling in favor of the defense on such issues was more likely to come from an appellate panel than from a trial judge. "Now, we turn to the trial and don't look back," the defense attorney said. "There is a case against Pugh. It seems like it is going to be the first one in a wave of cases to go to trial. There are federal prosecutors across the country who have filed these cases after Donald Trump and Attorney General Bill Barr called for them and said that local prosecutors should charge people who got violent during protests. A handful of the federal cases have ended in guilty pleas, but more appear to be put on ice or dropped in deals with defendants who stay out of trouble for a set period. Green Pugh, who faces up to 5 years in prison if convicted on a federal felony charge, has been handed an unusually stiff sentence for a nonviolent offender with no prior criminal record. The U.S. Attorney in Mobile filed a federal charge against Pugh just 5 days after the incident, which was already charged by Mobile police on inciting and criminal mischief charges. Last month, the U.S. Justice Department's headquarters in Washington sent an attorney to Mobile, Alabama, to defend its anti-civil disorder statute. No court has struck it down, but only one federal appeals court has upheld the law. The St. Louis-based 8th Circuit in a case involving 2 men convicted of throwing cherry bombs at firefighters as they tried to extinguish a blaze at the Air Force ROTC building on the Washington University campus. Pugh's conviction followed by an appeal would allow the Justice Department to seek another vote of confidence for the law from one of the most conservative federal appeals courts. One proposed argument against the law is that it needed a stronger link to interstate commerce. However, there are separate grounds for its use, and so this is unlikely to affect those cases involving interference with federally protected functions in Capitol crowds, regardless of any impacts on commerce.